Use USCIS Premium Processing Service. What is USCIS Premium Processing Service? On June 1, 2001, the U.S. Immigration and Naturalization Service, now the U.S. Citizenship and Immigration Services, put into place a premium processing service, promising to speed up the agency's application decision process on selected work visas. Under the USCIS Premium Processing Service, paying an additional $1,000 fee will guarantee a USCIS decision on eligible temporary work visas within 15 calendar days of receipt of the application by the USCIS. If the application or petition is not adjudicated within the 15 days, the additional fee of $1,000 will be refunded and the case will still be completed under the premium processing rules. The processing period that will be used to determine whether or not the USCIS meets the 15-day period will begin when the Form I-907 is delivered to the USCIS at the appropriate address and will end upon the issuance of a notice by USCIS. The notice may be a notice of approval, a request for evidence, an intent to deny, or a notice of investigation for fraud or misrepresentation. If the notice requires the submission of additional evidence or a response to an intent to deny, a new 15-day period will begin upon the delivery to the USCIS of a complete response to the request for evidence or notice of intent to deny. Who is eligible for USCIS Premium Processing Service? Beginning with the implementation of the program on June 1, 2001, employers filing a Form I-129 to classify a beneficiary under one of the following non-immigrant categories could request USCIS Premium Processing Service. These categories included the E1, E2, H2B, H3, L1, O1, O2, P1, P2, P3, and Q1. Since July 30th, 2001, the USCIS has made Premium Processing Service also available to employers wishing to file petitions to classify a beneficiary as an H-1B, a TN, or an R1 non-immigrant, thus covering all the major non-immigrant work visa categories. The USCIS also extended the Premium Processing Service to certain Form I-140s, immigrant petitions for alien workers. What is the fee for Premium Processing Service? The fee for the Premium Processing Service through USCIS is $1,000. The Premium Processing fee is an addition to all other USCIS filing fees for the application or petition. How to apply for Form I-907, Premium Processing. Application for Premium Processing of a petition is made by filing a completed and signed Form I-907, Request for Premium Processing Service, and attaching a separate remittance of $1,000. Form I-907, together with Form I-129 and the supporting documents, may be filed with the USCIS Premium Processing Service Unit of the USCIS Service Center. Upgrading regular petitions to Premium Processing. In the case where an I-129 petition has already been filed without a request for Premium Processing, the regular processing can be upgraded to USCIS Premium Processing Service by forwarding Form I-907 and the check for remittance of $1,000 to the Service Center where the I-129 petition is pending, together with a copy of the Notice of Action Receipt Notice, Form I-797, as proof of receipt by the petition at the Service Center. The 15-day guarantee. If the USCIS Service Center fails to process the petition within 15 calendar days, it will refund the $1,000 to the company and continue to process the petition as part of the premium processing. In addition to expedited processing, companies who participate in the program may use a dedicated phone number and email address to check on the status of their petition or ask any other questions they may have concerning their petition. Benefits of USCIS Premium Processing Service. When to use it. Premium processing can be very effective in certain situations. The first and foremost advantage of USCIS Premium Processing Service is its use for new employment of non-immigrant beneficiaries who need to wait for the approval of their petition to start work. This holds especially true for H-1B users subject to the H-1B cap. Let's take a look at a situation where premium processing would benefit both the employer and the employee. Juan finished his bachelor's degree in accounting and has been working for Company A on his optional practical training, OPT, since graduation. Juan's OPT will expire on December 31st, and Company A is not willing to file an H-1B for him. On December 1st, he receives an employment offer from Company B. Company B will sponsor Juan's H-1B, and they want him to start on January 1. If Company B uses the regular process, it could be 3 to 4 months before they get an approval for him, and Juan would not be able to work at Company A beyond December 31st when his OPT expires, or start with Company B until the H-1B is approved. By using the Premium Processing Service, the H-1B petition will be approved within 15 days of filing, and Juan will be able to start on January 1st. USCIS Premium Processing Service is also effective for cases pending on a regular track in which an RFE is issued. Petitioners may opt to convert such a case to premium processing when submitting an RFE response. USCIS Premium Processing Service, the darker side. In practice, premium processing has proven to be a blessing, though an expensive one, in many cases. It may not, however, always be necessary or advisable to use the Premium Processing Service. Premium Processing Service should be used judiciously. If the Premium Processing Examiner issues an RFE, the time sought to be saved may be lost by responding to the RFE. Also, premium processing may not be required at all, where the filing of the petition is properly planned beforehand.